Okay, if everyone could come in and take your seats.
I'll take on cam too, so you have time.
Yeah, there we go. Everyone come on in, let's go. Hello, hello. $10 to the first person that can sit down. Oh, he beats you right there.
Let's roll it. It's ready.
Perfect. All right.
Cool. Okay. I'm going to go work on breakouts.
Perfect. Yeah, that'd be
Is
great.
the exposure white balance?
All right, everyone, we're gonna move along because we want to get to our dinner and reception, right?
Can you make it
All
a
right.
little cooler?
Our next speaker is Greg Baylor from Alliance Defending Freedom. They are sponsors of our event, very graciously sponsored and put up money for this event to help it become fruition, to come into being. I want to tell you a little bit about Greg just really quickly. I got the luxury of having to do a podcast with Greg, and I found that we have a similar tie in our lives. There was a Christian psychologist at one time, who started a company called, Focus on the Family. Has anybody heard of Focus on the Family? Okay. Now, Focus on the Family became probably one of the biggest media companies, and at one time, the radio program was heard by over 200 million people daily. And he attacked many of the issues that we are still wrestling with today before anybody else attacked them. He talked about the influences and the negative influences on the family. He interviewed Ted Bundy on the role pornography played in his life and was the only media outlet to do that. But one day, I was traveling for business and listening to the program, and I remember James Dobson saying this specifically in 1993. He said, he bemoaned the issues that were impeding the family, that were infringing upon the rights of the family, and the desecration of the family. And he said, where are all the Christian lawyers? And you know what that did? That spurred a man by the name of Greg Baylor to become a lawyer. And so that's the backdrop of what we have today. The very organization, I think, Alliance Defending Freedom, came out of James Dobson's visions and what could be accomplished if Christians put their mind to changing the way that they're being treated legally. And so the protections and things that Greg's going to share are for our benefit. So Greg, if you could come on up, I'd really welcome you. If you could, give him a round of applause.
Thank you for that kind introduction. One of the interesting parts of that story is I was actually finished with law school yet. I had just started at a big firm in DC, and I had arrived at the destination after all these years going to school and all of that. And I'm like, is this it? Is this all there is? And while I was pondering those thoughts, I'm driving along. I'm on my way to the beach in Delaware, and I had a broken antenna, so I hardly got any radio stations. So I put on the little scanner, the seek button, and it's just spinning around. I forgot I was even doing that. And all of a sudden, the radio locks on to this station, WFSI, the voice of the new life, coming out of Annapolis, Maryland. And it was that program that locked on. So, like, you know, I'm a Presbyterian. I don't have a lot of Holy Spirit stories. That's my Holy Spirit story right there. But thank you again for having me. It's a pleasure to be back with many of you I know, and many of you I've had the privilege of working with. Some of you I don't know yet, but I hope we have a chance to connect. There are some things, there is going to be a to-do list coming out of this presentation. I think there's things that we can do to not just brace ourselves for threats to our religious liberty, but actually take affirmative action to deal with them and fix them through our elected representatives. I understand that you talked some about the one big beautiful bill, do no harm provision in at least one of your breakouts. Is that right? Am I hearing that correctly? I'm not gonna, yeah, okay, I'm getting some. So that's one of the things we're gonna talk about, but it's not the only thing we're gonna talk about. I'm gonna talk some other threats to religious liberty and some of the things that we can do about them. So first I am going to talk about this do no harm provision. If you're not familiar with it, it's a provision of the one big beautiful bill that will cause, in my judgment, if not dealt with, the largest defunding of religious higher education in American history. It's a provision of that bill that went into effect July 1st when the president signed it of last year. And as we'll discuss in more detail later, the Department of Education started digging in, and they proposed a regulation that's going to make things even worse than the bill itself. So first part of our conversation together, do no harm, one big beautiful bill. And then the second thing is the thing I almost always spend the most time talking about because it is the biggest threat to the religious liberty of orthodox religious institutions in the United States. And that's governments that want to tell you who you must or may not hire and admit as students to your institutions. This is the non-discrimination rules. Now, I don't think you or I have a problem with non-discrimination rules in general or in principle. I think it's good that we have a ban on race discrimination, sex discrimination, national origin discrimination, and all the rest. But it's when governments add sexual orientation, gender identity, gender expression, and even some other things that have been misinterpreted, where the religious liberty problems come. Right? These rules are designed, in many cases, to forbid us from living out our beliefs particularly about sexuality issues. So we'll spend quite a bit of time on that because I think it continues to be the largest threat. It has been probably for the last 10, 15 years, probably will be for the next 10 years or so. One thing to say about non-discrimination rules, they come at us from all angles. There tends to be, particularly we're here in Washington, D.C. right now, to have a little bit of tunnel vision towards Capitol Hill and the White House and the agencies. One of the downsides of our divided government is we have more people and governments to pay attention to. Things are happening at the state level, the local level, that threaten our religious liberty through non-discrimination rules. So we'll talk about some of that as well. And then the last thing, my time permitting, is what I call, and a lot of folks call, sort of strict separationism. You know, there's sort of this idea that, yeah, we have separation of church and state, which is fine to a degree, right? We don't want the state in our business. But at the same time, there have been many interpretations of this idea and ported into constitutional law, federal and state law, that means the government must discriminate against religion. The government must discriminate against religion. As Richard John Newhouse said, we must have a naked public square. And one of the particular manifestations of this historically has been the idea that government can fund things, they can fund education, they can fund social services and all of the rest, but they must, because of strict separation, because of separation of church and state, discriminate against religion. And we're going to talk about how that came about, how it's changed, and how we're actually making progress towards equality, towards a level playing field, towards equal treatment. All right, so those three things we're going to try to cover in the next 45 minutes or so. And I hope we'll have time for questions. I realize I'm standing between you and the reception, so I'll stick around a little bit afterwards. If you don't want to hold everyone up, if you have a question, you can either ask it when we're together, you can ask me separately. On Tuesday, I was here speaking to the K through 12 folks, and I was the one between them and dinner. So needless to say, there weren't a lot of questions until right afterwards. So don't be bashful, but I will stick around for more of those. Okay. The do no harm provision, what does it do? It's essentially a piece of the one big beautiful, it is a big bill, right? I don't know how beautiful it is, but it's really, really big, and it touches on a lot of things. One of the things it did was to amend the Higher Education Act. And my understanding is that the majority of Newman Guide higher educational institutions do participate in Title IV, Higher Education Act Title IV programs. I know that some of you do not, but that most of you do. I apologize to those of you who don't participate. Maybe you can sit back and feel smug that you didn't participate, because we're going to talk about problems with participation in that program. I think I've heard some people say they wish they had a time machine so they could go back and, be Wyoming Catholic or Grove City in the Protestant world and just not get started taking the federal money, but here you are. Again, most of you are participating to some degree in Title IV programs. Okay, so one big beautiful bill passed Congress, signed by the president in July of last year. One observation I'm going to make that will become important, or could be important, they passed this via reconciliation. By reconciliation, you hear these words like, what are they doing? I think the most significant thing about reconciliation is it's not like a normal bill where the House has to pass it 50% plus one, and the Senate needs 60 votes, right, to overcome the filibuster. Reconciliation is a different animal, and you can pass it by 50% plus one in both houses, House and Senate, and that's how reconciliation passed. The other observation I'll make about reconciliation, it's this incredibly large bill, and it all happens really, really fast. So it happened under time pressure. The president really wanted to make a big deal of signing it on July 4th. So there were, I think, not all of the potential consequences, particularly of this do no harm provision, were taken into account before they signed it into law. So just two observations at the outset. Okay. So what is it? It's about, okay, let me start. It's about direct loans. There are different forms of Title IV. The most famous ones are Pell Grants and Title IV loans. Direct loan, the William D. Ford Direct Loan Program. This provision is about the loan program. And essentially what it says is, if the graduates of a particular degree program don't earn enough money, then the current and future students in that degree program will be ineligible for direct loans. So they look at the grads, look at how much money they earn, they make a comparison to something, I'll mention that in a minute, the government decides, is this enough money for us to continue giving loans to students in that program? Okay? So the value of the education and the consequences for not being sufficiently valuable are entirely based on how much money somebody earns, right? Entirely based on how much money somebody earns. So that's the value of it. That's the premise behind this. So why do they call it do no harm? I hear do no harm, I think about, the Hippocratic Oath and doctors and all. No, the idea is, let me back up and explain what they compare it to. So if you get a bachelor's degree, and you go out and you're earning money, what they compare the graduates of a program to is people in, and it depends, the state or the whole country, who just got a high school diploma. So if you got a bachelor's degree and you're not earning more than the average high school diploma holder, then you're not earning enough money, and therefore the current students lose their direct loan. So the idea is, it does someone harm when they get a degree and then make less money than they would have made had they just had a high school diploma. They wasted 4 years, they wasted X number of dollars, they wasted the government's money, et cetera, et cetera. That's why it's called do no harm. People are worse off, in their view, if they make less money than if they just stopped their education after high school and moved ahead. So that's why it's called the do no harm provision. For graduate students, professional degrees, they compare it to bachelor degree holders, right? So when I say enough money, or you're earning enough money, that's who they are comparing it to. One of the interesting things about this is the first time there really is an accountability measure with consequences for public universities and for private nonprofit entities. There have been experiments really over the last 10 years or so with trying to impose consequences on the proprietary schools, the for-profit schools. A lot of them are career-related, because there's been a lot of abuses there. A lot of people pay a lot of money. The government's putting a lot of money into those degrees, and people are just not getting what they used to call, and still call, gainful employment. So this was the first time they're really trying to mete out consequences on institutions like yours, nonprofit, private ones. So when it passed, I don't think a lot of us, I certainly wasn't, sitting here going, this is going to be a problem for religious institutions. Now in hindsight, I probably should have thought that, because think about it, a lot of people, not so much all of your graduates, but think about seminaries, Bible colleges, and even your degrees that are training people for religious vocations. Do people get into that for the money? No, they don't get into that. Your faculty who are working at religious institutions can tell you they didn't get into it for the money, although they might have some complaints. But it's just, I mean, I could probably make more money in a for-profit law firm than I could at a religious nonprofit. Everyone understands this, and I don't think it's a bad thing, right? I mean, nonprofits are devoting the share of their resources to serving the people they serve, not to try and compete with secular employers on salary. So I guess we should have seen it coming. Maybe some of you did. I didn't. When did we really understand that this was going to be a problem for religious institutions? Well, the Department of Education conducted something called negotiated rulemaking. Some of you may be familiar with that more than others, but it's what it sounds like, right? They're going to generate a rule, a regulation, right? But they're going to not just do it the normal way, which is where, the department people get in, they get behind closed doors and they write up the regulation, they throw it out there for people to comment on, then it becomes front. No, they bring people into the process. They have a negotiated rulemaking. So these are public hearings, and they invite people to serve on the negotiated rulemaking committee. So all of this happened in late 2025 and early 2026. The most significant thing about the negotiated rulemaking was an analysis that the Department of Education did. They wanted to know what kinds of programs would fail the earnings test. What kind of programs graduates are not earning enough money. So they do this analysis, and then they publish the results, and that's when a lot of us went, oh my. So the results of their analysis showed that 53.3% of undergraduate programs in religion or religious studies would fail the earnings test. Over half of undergraduate programs in religion and religious studies. I don't know if you discussed it in your breakout, but when you say religion and religious studies, if you're familiar with the CIP codes, classification of instructional programs, it's, they're 2-digit, 4-digit, 6-digit. It's 39, which is the main one, and then 38. So that's the category when they say religion, religious studies. So 53.3% of those programs would fail. And looking down the road, these are the programs no more direct loans are going to flow to, 53.3. At the graduate level, it's even worse. It's 89.4%. 89.4, like almost 9 out of 10 of these programs, they're failing because their graduates don't earn enough money. So that's when everyone started to, kind of freak out a little bit and like, oh, this is a problem. Okay, so the negotiated rulemaking moves to then like the more formal rulemaking process, which is what we're in right now. At the end of the negotiated rulemaking, we saw an idea that became embodied in the proposed rule that the department is finalizing right now. The way I like to describe it is they took the pain that was going to come from the do no harm provision of the One Big Beautiful Bill, and they amplified it. They didn't mitigate it, they amplified it. So the whole idea is, if you're familiar with, if you're in charge of compliance with Title IV, there's a whole separate thing about administrative capability. And as it sounds, it suggests it's like your ability to administer the program, right? It's not about substantive things, it's just like your logistical competence, right, in dealing with the program. So, but they added something there that says if you have enough of these failing programs, right, that are getting the direct loans that are failing the test, or if you have enough students in those programs, then we're going to amp up the pain on you. First, we're going to take away other forms of Title IV aid from those programs, most significantly Pell Grants. And then if you are in this status for long enough, we're going to take everything away from your entire institution. Your entire institution is deemed administratively incapable, and you lose all of your funds. So I think this is a probably more significant problem for seminaries, for Bible colleges, where the percentage of their students in SIP 38 and SIP 39 programs is high. It's perhaps less of a problem for like a liberal arts institution whose low earning programs are diluted to some degree by their other degree programs. But this came up on the last day of negotiated rulemaking and was put in the proposed rule, and this is a big problem too, right? I mean, this, like I said, it just amps up the pain for those institutions that have these so-called failing programs. So, all right. So the proposed rule came out. Like most rules, you get it, and it's like yay thick, and 90% of those pages is what they call the preamble to the rule, and the rest is just the changes to the rules. So you look at it and you read through it. They justify or try to pre-justify what they're doing. They're trying to explain what they're doing. They're trying to say, here are some alternatives we considered. They're justifying their rationales. They're justifying their legal authority to do all of these things. One of the very interesting things that happened was the department gave very different numbers about the failure rates in a lot of degree programs, categories of degree programs. The alleged failure rate for religion, religious studies sort of plummeted, down around 20% or something like that. I don't understand it. I know there are people who understand it slightly more than I do, but they say they don't understand it. Maybe you guys understand it. But nonetheless, they conceded that this rule will still have a disproportionate effect on religion and religious studies programs. They said that for example, undergraduate programs in SIP 38, 39 will fail at a rate 5 times higher than the average undergraduate bachelor's degree program. So I honestly don't know what the number is. We may not be able to know until it goes into effect, which I hope it doesn't, at least for your programs, for religious programs. So I just, it's conceivable. I don't know. I wasn't in the room. They may have looked at those numbers and said, wow, this is really bad. When we came up with this provision, we were thinking of, basket weaving and cowboy poetry and social justice warriors. We weren't thinking of our friends in the conservative religious community. So maybe there was a little bit of, jiggering with the numbers. But so even though it might not be as bad as it first looked, it's still bad. Does that make sense? Okay. All right. So where are we now? So they published this proposed rule, and they accepted comments. It was published on April 20th. Comments were due on May 20th. There were a few of you in the room who submitted comments. I know the Cardinal Newman Society itself submitted a comment on the rule. Way to go. Catholic University, where we are, submitted a rule. Catholic International University submitted a comment. I don't know if there are any other Newman Guide schools. I couldn't find them. Did anyone who I didn't mention submit a comment? It's not your fault if you didn't submit a comment. It's just, these things are hard to pay attention. Anyway, the good news is that lots of religious institutions, lots of religious school associations submitted comments and complained about this problem. So they know, right? They know that religious institutions and their associations have a big problem with it. So they're going to consider our comments. What the comments mostly said was this is really bad for religious education. Some institutions sort of dug down a little deeper and provided data. They talked about, okay, I'm a Bible college and 90% of my students are in a SIP 39 program, and this is the amount of money that they were lent, and this is the amount of money that is at stake or is at risk. Oh, and by the way, this is more than 50% of our students, or more than 50% of the money. So we're at risk of failing the new administrative capability. So we're going to lose our Pell Grants too. So, you have schools that are pointing to the numbers, right? Very explicitly. So that's good that that's in there, because the department must deal with it. The other thing that's good about it is we're not, well, let me tell you what the comments are asking for. We're asking for a religious exemption from the application of the do no harm test. And that exemption would be for SIP programs 80, 38, 39, and they would be for religious institutions who qualify for Title IX's religious exemption. So it's not every school, it's not every program at a religious institution, it's the religious studies programs at religious schools. And I'm confident that every Newman Guide school would qualify for this exemption because you do qualify for Title IX's religious exemption. So that's what we put on the table, a lot of other groups put on the table, individual schools put on the table, Cardinal Newman Society put on the table. So we put that in front of them. The good thing about having that data from those schools is we're making not just a, hey, help out the religious community argument, we're making a legal argument too. Our legal argument is that if you apply this test to religious study programs at religious schools, you're violating their legally protected religious liberty rights. You're violating the rights of students, you're violating the rights of institutions. What rights are we talking about? Well, you know the Religious Freedom Restoration Act, right? People familiar with that? You know, that was what the Little Sisters used to win their case against the Obama administration and the contraceptive mandate. One of the things you have to argue, show in court or before an agency is that, hey, this rule that you're trying to apply to me, it really burdens my religious exercise. So if you can quantify that and say, you know, we had 300 students who were getting direct loans for religious studies programs, and they got $750,000, you know, or $2 million. You know, you're quantifying the harm. That's important. The department has to deal with that. So ADF's the comment that ADF wrote on behalf of a couple other associations played out the rest of the legal argument. Okay, here's the burden. If you can establish there's a burden on religion, the next question is, the court turns to the agency, turns to itself and says, what's your objective here? What are you trying to achieve? And then the legal question is, how compelling is that interest? How compelling is that interest? Is it national security? Is it life and death? I don't think so. You know, it's not even saving money, because we're talking about loans here. I mean, maybe Pell. The default rates from religious institutions are low compared to everyone else. You know what? I like to think of it as the interest is protecting people from themselves. That's what they're trying to do. No, you shouldn't choose that degree in religious studies because you could make more money with your high school diploma. So we know what's best for you. I know you want to be a priest and make less money than the high school graduate, but that's less good for you. So that's really the government's interest, is protecting people from themselves. So if I'm a judge, I'm like, that's not a compelling interest. The other thing that they ask and that we argued about in our comment is, have they chosen the least restrictive means? Have they chosen, are there other ways you can accomplish this objective without imposing such a tremendous burden on religious exercise? And we think the answer is yes. Okay, so all these comments are sitting there. The department is reading through them. There are, I think, almost 9,000 comments on this. A lot of cosmetology folks out there who submitted comments. They were organized, but a significant number were from the religious community as well. What happens next? It takes a while for them to process these comments, and they have to. That's the law. They have to do it. They have to do it right, and then they have to decide what they're going to do. So months, maybe not even till next, I don't know. I heard they're going to try to do it by the end of September. That's going to be tough. That's going to be a challenge for them, but who knows? Maybe they'll do it by then. The provision goes into effect July 1 of 2026. So that doesn't mean they start taking away direct loans, but that's when they start counting the salaries of the graduates. Right? That's when they're starting to, you're comparing this and that. That's when they start measuring that. And you have to fail 2 out of 3 years, so it will be a couple of years before, if it's left untouched, before someone actually loses their direct loans. But one of the provisions is if you fail 1 year, you have to warn all the students in that program. guess what? You're probably not going to get a student loan for this program next year. I mean, what does that do, right, to the institution and to those students? So, the pain will come not on July 1st, 2026, but it might come like next summer or shortly thereafter. So, it's going to take a while. We're hopeful, cautiously optimistic that they will put in this religious exemption. I think it's a strong argument that it's required by RFRA. They have the authority under RFRA to put in this exemption. And, we're the sort of constituency that, generally speaking, the Trump administration is sympathetic to, or at least has been. So, I mean, they've been on the side of religious liberty for the most part. So I'm hopeful that that general trend follows through in this context. But we're not working just the administrative angle. And this is where your homework comes in, homework that I hope you will do. We brought this before Congress. ADF, other groups. I work closely with the Association for Biblical Higher Education, with the Association of Protestant Bible Colleges. I'm actually on their board. When I joined the board, I told the chairman, I'm not sure there's going to be anything for me to do on this board. I'm not sure what value I add. And now it's like, this is what we're doing, right? We're spending all of this time trying to lobby not just the agency, but Congress, and trying to equip the members of that association to make the case, right, to their senators and their congressmen. That's what I'm going to be asking you to do. And Patrick and I have talked about this, so he's cool, I think. Yeah, he's good with it. So, what can Congress do? Well, this problem was created by legislation for the most part, right? The do no harm provision, so it can be fixed by legislation. Right? Easier said than done. It's really hard to pass anything in Congress, so if you have your betting man, Congress is not going to fix this, but we got to try. There are at least 3 ways they could do this. There's this process called reconciliation, which I mentioned before. They created it by reconciliation. Maybe they can fix it by reconciliation. We didn't think there was going to be another reconciliation bill, but there was one just recently, Reconciliation 2.0, which was about the border and other things. And now there's some talk of a Reconciliation 3.0, so that, Congress can do things that their constituents want, at least the Republicans in Congress can do things. So that's an option. The appropriations process, that's underway right now as well. The idea here is we're Congress, we're giving money to the agency to enforce all of these laws and do all the things that agencies do. And the provision that we wrote and we've circulated on Capitol Hill says, Department of Education, all this money, you can't use any of it to enforce the do no harm provision or any regulation that comes into effect afterwards against SIP programs 38 and 39 at religious institutions. So it just says, you can't enforce it. So it achieves the same objective. It just does it through this. We're going to deny you the money to enforce this thing. And then the third way is a freestanding bill. Highly unlikely, but it is good as a way to talk about the issue, to heighten people's consciousness about it. Appropriations also requires, I was about to say that the freestanding bill would require 60 votes in the Senate, so that makes it really tough. Appropriations requires 60 votes, but there's more of a trade-off going on there, so it makes it slightly more possible. I'm not confident that this is going to be fixed by Congress, but one of the things that is happening, which is encouraging, is Congress, at least individual senators and congressmen, are communicating with the department. And they're saying, hey, I'm hearing it from people. I like these people. These are my friends. I'm a religious liberty person. And so I've been told they're talking to the department. So I think the congressional advocacy it's almost like indirectly lobbying the agency. We can't do much with the agency right now because the comment period has closed, and they're just supposed to do their work, right? But members of Congress can kind of do what they want. So part of the objective is by sharing your story with senators and congressmen, they will in turn share it with Congress. So how do we do that? How do we do the story? We developed a spreadsheet that looks way more intimidating than it really is. It's basically a tool designed to collect data about how many students do you have in these degree programs, SIP 38 and 39, and how much loans do they get, and how much Pell Grants have they gotten, because those are at stake too. It's really simple, but it looks complicated because there's a lot of categories. You know, there's like undergraduate certificates, bachelor's degrees, postgraduate certificates, you know what I'm saying? There's a lot of categories, but it's really not hard to do. I know that you all have this information more or less at your fingertips, and there's someone on your staff who could do this. So with Patrick's cooperation, we're going to send out the spreadsheet in the hope that you fill it out. That's step one. Step one is to take that information and put it in communications, both written and oral, with your elected officials, senators and congressmen. So we've got a model letter that people can use, they can not use. We've got a spot there where you can incorporate the data that you get through the spreadsheet, what the harm of the do no harm provision is going to be on our school, and ask them to take action, right, legislatively and indirectly through talking to the Department of Education. So hopefully you'll be getting those two documents, the model letter and the spreadsheet. My thought was that if you fill out the spreadsheet, feel free to provide that information to me, and I can help take that and put it into the model letter. If you don't want to do it that way, that's fine as well, but I'll give you that option. Okay. Last thing down there at the bottom, what if none of this works? What if none of this works? I think there's a good lawsuit, right? I mean, the whole argument in our comment to the department was this violates the Religious Freedom Restoration Act. This violates the rights of school and students, right? And it's a substantial burden, and there's not a compelling interest, and this is not the least restrictive means. So judge, tell the department that they can't enforce this. That would be sort of the goal and the argument in the litigation. So, I mean, who knows? If we get to that place, I can imagine some of you participating in that litigation. I don't know if it's going to be like the contraceptive mandate where there were hundreds and hundreds of plaintiffs, but there are going to be hundreds and hundreds of victims of this, both institutions and students. I mean, thousands, tens of thousands of students, if this goes through, are going to lose their direct loans and possibly even their Pell Grants. So that's down the road as a possibility, but even the data that we're collecting now could be useful towards that end. So I'm gonna stop there before I move on to my other two things and see if there's any questions or comments about this whole do no harm accountability deal. Any questions? Yes, sir. Yeah, I think almost all liberal arts institutions have SIP 38, particularly 38. 38's more philosophy than religion. And even in SIP 39, there's like Jewish studies or Hindu studies. I mean, I went to a secular college and you could take that, right, and major in that. So I suspect that, you know, if you go to Harvard and get a degree in religion, you might make more money than, you know, someone goes to a Bible college and is a youth pastor in rural Ohio or something like that. But yeah, it affects, it does affect, you know, other, now the exemption that we're proposing, they would not be eligible for it because they're not a religious institution. Other questions? Yes. Yeah. 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 Right. I was afraid someone was going to ask this because I'm not conversant with the way that they do all the calculations. I was in a presentation listening to it, and my reaction to all of this was like, this is interesting, but it's only on the margins. Like, the real problem is the fact that there's an earnings test at all. So even if you like configured it in a way to make it less bad, it would only make it slightly less bad. I guess I am trying to dodge the question, but you know, it is for the working adults that they're comparing it to. It's 24 to 35, and they use IRS data. They use any data that they can find. As far as your graduates, I think it's like, you know, the first couple of years you get out, and a lot of people complain, but you know, people are going to make more eventually. Don't worry about it. So, yeah. Did you have more to say? Okay. Yeah. Yeah. No. Right. Yeah. So, I mean, one of the other reasons why I didn't pay a ton of attention to that, this is my own defense, There's no legal argument that you could say that that violates the law, the way that they're counting it, or it's unconstitutional. Also, I don't think Congress is willing to do anything at all to fix this other than perhaps a religious exemption. In my view, that's the only thing that's plausible. They're committed ideologically, right, to this do no harm test, to this accountability. There's a lot of distrust of higher education in conservative and Republican circles, and you all get lumped in with that. I know you know that. So I was focused on things that I think maybe we could, fix. But I'm happy to provide you all the boring discussion of that. Any other questions before we move on? Okay, very good. All right, let's talk about normally the thing I talk about most, non-discrimination. I understand in the breakouts there was a discussion of this Zinsky case, Zinsky versus Liberty University. That's the third one down. I'm going to go there so we can get to it without running out of time. Okay, so Title VII. Title VII, you know what it is. It bans discrimination in employment, race, color, religion, sex, national origin. Doesn't have SOGI, sexual orientation, gender identity. This is the federal law, 15 or more employees. In 2020, the Supreme Court said the ban on sex discrimination includes a ban on sexual orientation and gender identity discrimination. So voila, we have amended Title VII to include SOGI. One of the big questions that came up was to what extent, if at all, does the existing religious exemption in Title VII protect a religious employer like your schools from a claim of sexual orientation and gender identity discrimination, especially where the schools or the employer's views about transgenderism, about homosexuality, are rooted in their religious beliefs, right? Because it's really I would say, if one of your schools took an adverse action against an employee who is trans or is in a same-sex relationship or whatever, that's not coming out of nowhere. That's connected to your religious beliefs. So this was the legal question. Does the exemption protect from SOGI claims? The language of the exemption says you can prefer people, quote, of a particular religion, So you can see what the other side says, right? Religion is religion. Sexual orientation, gender identity are separate categories. Therefore, you're not protected. Our counter argument is, well, what is religion? Is religion simply the statement of faith? Is it simply the catechism? Is it simply the Apostles' Creed? No, it's not just orthodoxy, it's orthopraxy as well. So when you say of a particular religion, that means you're hiring people not only who agree with you about the Trinity, the virgin birth, the authority of the church, but also live a life that's consistent with the values that are expressed in the Bible and in those sort of documents. So that's the fight that's going on right now. I'm sorry to report that we've mostly lost this fight in the lower courts. Really all of the decisions have been at the district court level. That's one of the reasons why this hasn't blown up into a big, high-profile issue. I think the other reason is, in a lot of these cases, the religious employer will lose on the Title VII religious exemption argument, but they'll win on some other defense. So some of these cases where they lose, they end up winning because of, say, the ministerial exception. You all know what the ministerial exception is, right? You have to prove the person's a minister, then all bets are off. You can do whatever you want in terms of discrimination law. So that's another reason why I don't think this has risen to the profile. Zinsky is significant. Zinsky versus Liberty University is significant because it's likely to be the first court of appeals, federal court of appeals in the country that squarely addresses this issue. Right? So district courts, court of appeals, Supreme Court. There are 11, 12 geographic, there are 13 courts of appeals. This Zinsky case, Liberty's in Virginia, Virginia's in the Fourth Circuit, South Carolina, North Carolina, Maryland, West Virginia are in the Fourth Circuit. So this decision will matter a lot for everyone. It will matter especially for those in those Fourth Circuit states. You may have talked about what the case about. It's essentially someone who got hired at Liberty. transgender. After a few months, they announced they're transgender. This is inconsistent with the documents that they signed, with the promises they made when they were hired. And Liberty took adverse action based on its doctrine about transgenderism, discharged the employee sued, and off we go. So Liberty asked the case to be thrown out at the trial court, and they did the thing. You know, they said Title VII religious exemption, ministerial exception, other things. District Court didn't buy it. Case is now at the Fourth Circuit. I'm pretty sure Cardinal Newman Society joined an amicus brief in support of Liberty. Yes, Bob is shaking his head. Yeah, virtually certain of that, which is great. Thank you for doing that. Oral argument has occurred. Didn't go great for our side. A lot of times you know in advance by the composition of the panel, like which president appointed them. And it was 2 by Democrat presidents, 1 by Republican president. So, you know, I'm not super optimistic this will come out the right way. The real question is whether, if and when Liberty loses, whether it'll go to the Supreme Court. Whether it'll go to the Supreme Court. I would guess that Liberty would ask the Supreme Court to take the case. I don't know if they'll take it. They usually like to have, you know, a conflict in the circuits. You got one circuit saying this, one circuit saying the other thing. But to me, this is a significant enough question, right? And that's the other criteria, that they ought to take it. Whether they will, we'll see. But you know, this would be a bad development. And yes, question. Yeah. So the question was, why isn't this like Our Lady of Guadalupe, where they won on the basis of the ministerial exception? Right. So this person is an IT, I should have said this. This person is an IT help desk worker who has no contact with hardly anybody, like in person. So there is some speculation, I'm inclined to believe it, that this was a setup, that the ACLU did this on purpose, and that they wisely chose someone in a job position that it's really tough to argue is ministerial. So that's why it's different from Our Lady of Guadalupe, because the people in that case, they're teachers, basically teachers at least at K through 12 and probably at the university level are ministers for purposes of the ministerial exception. But not everybody who works at a religious employer is a minister. And the court agreed with the plaintiff, with the ACLU, that this person was not a minister. Right? Don't quote me, but I think it's probably right. I mean, it's a tough argument to say this person's minister. So that's the answer. Does that make sense? I mean, I think it was deliberate, right? They wanted to, you know, raise the question, right, rather than the case go off on the ministerial exception. Okay. So, yeah, the possibility of a congressional solution to this, 0. We pushed hard in 2000 for Congress to do that. There was no interest. You couldn't get 60 votes for that. So I think we're just going to have to win this issue in the Supreme Court. But in the meantime, I would not advise any school to significantly change or change at all its practices and policies. The one thing I might do would be to make it clearer that what you require is not only a compliance with a behavioral standard, but agreement with the theology underneath that behavioral requirement. So when the person comes and says, I'm in a same-sex relationship, the basis for the discharge isn't just their violation of the conduct standard. The basis of the discharge is their disagreement with your religious beliefs. That's what the Title VII religious exemption is all about. We get to hire employees who agree with us on doctrine. They want to make it something other than that. It is that. Yes, it's about conduct too, but you can make it at least half or whatever about their disagreement with doctrine. So that would be the one piece of advice I would make, even if the case doesn't go the wrong way. That's the right way to think about any of these conduct, if they implicate something religious, is to characterize them that way. Okay, how are we doing on time? We're running out. Okay. Title VII, still talking about Title VII. One of the other issues that came in after the Bostock decision was entered was what things count as gender identity discrimination. In that case, it was purely like a status thing, like, oh, you're trans, you can't work here. It wasn't about bathrooms or pronouns or anything else. It was just about status. So the next one of the questions is, what about the person who says, I work here, I'm trans, I want to use the bathroom that's consistent with my gender identity rather than my biological sex, the employer says no. Is that gender identity discrimination? I don't think it is, right? This rule is based on people's sex, not on their gender identity. You're not singling out transgender people for worse treatment. Everyone has to use the bathroom consistent with their sex, trans or not. That would be my argument, but I think unfortunately, most judges and other adjudicators say, yeah, that's gender identity discrimination. One of the arguments that's been made is that if you exclude so-called gender-affirming care, puberty blockers, cross-sex hormones, surgeries, if you don't include those in your employee health plan, you're committing gender identity discrimination. That's an argument that's starting to be made. The good news is, there haven't been a lot of cases, but the most important high-level case, the 11th Circuit down in Georgia, said no, that is not gender identity discrimination. So, but I think we'll continue to see that. Let me say something really briefly about disability. So Title VII never got amended, right? No one ever added SOGI to it. The courts amended it. This is what's going on with disability as well. For years, I didn't think disability laws created religious liberty problems. But now they are, because the argument that gender dysphoria is a disability has taken hold and been accepted by a number of courts. And of course, that raises the next question, well, what things count as gender dysphoria discrimination? Well, you can guess, right? You're not giving me access to the bathroom of my choice, you're not including gender-affirming care in my health plan, you're not using my preferred pronouns, and in the school context, you're not letting me, a boy who identifies as a girl, play on the girls' sports team. So most of these cases have been in the prison context. So they're not getting a lot of publicity, but all of you that participate in Title IV, not only are you dealing with the one big beautiful bill, do no harm provision, you have to comply with Section 504 if you're a recipient of federal financial assistance. What's 504? Section 504 is that law that forbids disability discrimination by recipients of federal financial assistance. Is there a religious exemption in Section 504? No, there is not. There is no religious exemption in Section 504. So this is what I worry about, right? Is someone making the claim against a school that gets Title IV funds, you violated Section 504 by not admitting me because I'm trans, or not letting me have access to the right bathroom, playing on sports teams. The Biden administration agrees with this, did agree with this. The Trump administration has kind of backed down and issued some helpful statements, but ultimately it'll be the courts to decide. Church autonomy defense. Remember when I was talking about these cases where they'd lose on the religious exemption, the Title VII statute, and they'd win on something else? The something else is sometimes ministerial exception, but there's a recent case that ADF litigated that's really, really helpful, especially if it spreads to other places. It essentially says it doesn't matter if you're a minister. There's another defense called the church autonomy doctrine. And it gives religious employers the legal authority, the power, notwithstanding any non-discrimination rule, to prefer co-religionists for any position, ministerial or not. So that was going on in this case. It involved a rescue mission in Washington State. The employee was non-ministerial, at least that's what the court said. So it was a state law case, so the exemption was not applicable. Ministerial exception, we didn't win. Plan C was church autonomy, which the court agreed with us that protects the religious employer's freedom to prefer co-religions, including compliance with conduct standards that are rooted in religion, with respect to any position. So this is a powerful, powerful case. It was decided in the 9th Circuit. It used to be terrible. Now it's okay. The 4th Circuit is the terrible one now. That's where the disability case comes from. Obviously, the Zinsky case is there. So that's a good development. The last thing is there are a lot of legal challenges going on where the governments are conditioning benefits on compliance with a non-discrimination. I mean, Title IX is an example. Section 504 is an example. But a whole bunch of other laws, state laws in particular. If you want this benefit, you've got to comply with non-discrimination rules. And ADF's been filing these cases. Our friend at other organizations have been filing these cases, and we've had a fair amount of success. We had success in Colorado, in Oregon, but the most important thing I wanted to mention is Beckett Fund has a case that'll be argued this term and starts in October about this very issue, the conflict between a non-discrimination rule and sort of associational freedom and access to government benefits. Colorado created universal pre-K. They decided it wasn't so universal. If you're a pre-K provider who takes religion, sexual orientation, gender identity into account in employment, not in the kids, in employment, then you can't be eligible to participate in the pre-K programs. ADF filed a case, we got a preliminary injunction. Beckett filed a case, they didn't, they appealed, it's at the Supreme Court. I'm cautiously optimistic that Beckett will win that case and we will all win that case and establish yet another precedent that constitutional rights can supersede, override, be superior to sort of LGBT stuff. We've seen it with the public accommodations, the vendors, we've seen it in the employment context, and hopefully we'll see it in this context where government's trying to put strings on conditions. So I'm going to leave the last part out, the strict separation, and we'll save it for a separate day. But good things are happening. You know about Blaine amendments, right? The vestiges of Blaine are everywhere. They're in the federal code, they're in the federal statutes, they're in state statutes. Notre Dame Law School has launched a project where they're identifying all these unconstitutional discriminatory laws and rules, and ADF has taken up the project of introducing legislation in the states to fix this. So there's the Notre Dame website. You can go in there and you can see a lot of them have to do with education, right? So that was the real bugaboo. We don't want to fund Catholic education in the 19th century, and a lot of these laws still exist. So Notre Dame started this project. We got a law passed in Iowa this year, and in Florida, the Attorney General there said all of those laws that discriminate against religion, they're unenforceable because they're unconstitutional. These are the laws that we plan to introduce legislation in, to fix, to take out all these discriminatory provisions. And I'm the one responsible for writing all of those, so pray for me. Is that to write all these? Because everyone is different. There's no one side, you have to look through the whole code and find things. So, but good things are happening. We're winning the cases on this issue, and we're trying to win this issue to create a level playing field, to create fairness, not just by litigation, but through legislation as well. With that, I will stop and answer any questions that you might have, either here publicly or privately after we're done. Thanks for your attention.